Imagine it's 11 p.m. on a Tuesday and you're settling in for the night. You're just about to turn off the lights when you hear a heavy, authoritative pounding on your front door. Your heart rate instantly spikes because you were not expecting guests. You check the peephole and see two uniformed officers standing on your porch. They shout the words that make every citizen freeze. "Police, we have a warrant. Open the door." Your mind races with confusion because you know you haven't done anything wrong. You feel a sudden, overwhelming pressure to comply because they are the police and they said the magic word. So you unlock the deadbolt and swing the door open. By the end of this video, you will understand exactly why opening that door might be the biggest legal mistake of your life. I'm Sarah, and today we're breaking down the complex reality of search warrants. We're going to walk through a realistic scenario to show you exactly how rights are lost in seconds. We will explain the specific legal phrases you need to know to protect the sanctity of your home. And most importantly, we'll tell you exactly what to say when police claim they have a warrant. Let me tell you about a guy named Marcus. Marcus is a 27-year-old graphic designer living in a quiet suburban rental. He has no criminal record, no illegal contraband in his apartment, and no reason to fear the law. But tonight, the police are at his door looking for a previous tenant who hasn't lived there in 3 years. Marcus hears the pounding and the command to open up. He's terrified that if he doesn't open the door, the police will kick it down. He thinks that having a warrant means the police have absolute, immediate authority to enter no matter what. So Marcus opens the door and says, "What is going on, officers?" The officers step inside without pausing, filling his small living room with their presence. Marcus has just accidentally waived his Fourth Amendment rights without even realizing it. This brings us to the first and most critical legal concept you need to understand. It is called the principle of voluntary consent. In the United States Supreme Court case Bumper versus North Carolina, decided in 1968, the court established a massive precedent. The court held that consent is not valid if it is granted only after the police assert they have a warrant. However, the burden of proof is complicated. If Marcus opens the door and steps aside, the police might later argue in court that he opened it voluntarily. They might write in their report that Marcus invited them in to clear up the confusion. This happens in courtrooms across America every single day. By opening the door, Marcus gave up the physical barrier that protects his privacy. Now, let's rewind the scenario and see what Marcus should have done instead. When the police yell, "We have a warrant," you must not panic. You generally have the right to keep your door closed while you verify their authority. The first specific phrase you should use is a request for verification. A person in this situation might shout through the closed door, "Please slip the warrant under the door or hold it up to the window so I can see it." This is not resisting arrest. This is verifying legal authority. If the officers actually have a search warrant, they generally must possess it physically to execute the search. This brings us to our first technical legal term, the particularity requirement. The Fourth Amendment requires that a warrant must particularly describe the place to be searched and the persons or things to be seized. A warrant is not a blank check that allows police to go anywhere and do anything. It is a specific instruction from a judge with strict limitations. If the police hold the warrant up to the window, you're looking for 3 things. First, does it have a judge's signature? Second, is the address correct? And third, what is the scope of the search? If the warrant lists your address as 123 Maple Street, but you live at 125 Maple Street, the warrant may be invalid for your home. If the warrant authorizes a search for a stolen 60-inch television, police likely cannot search inside your jewelry box. Why? Because a 60-inch television cannot physically fit inside a jewelry box. If Marcus had asked to see the warrant, he might have noticed it was for the previous tenant. He could have said, "That person does not live here. I am the leaseholder." However, you must understand the reality of police procedure. Sometimes, even if you point out the error, police will enter anyway. This leads to the most important safety rule in this entire script. Never physically resist the police, even if you believe they're wrong. Fighting the police at your doorway is a recipe for violence and additional criminal charges. Your goal is to preserve your rights for the courtroom, not to win a physical fight on your porch. So, if the police insist on entering after you've checked the warrant, you need a second phrase. You should clearly and audibly state, "I do not consent to this search. I am only complying with your orders." Why does this sentence matter so much? It prevents the police from claiming later that you agreed to the search. If a judge later determines the warrant was invalid, your clear statement of non-consent is crucial. It brings into play a legal doctrine known as the exclusionary rule. This rule generally prevents the government from using evidence gathered in violation of the U.S. Constitution. If Marcus had let them in voluntarily, the exclusionary rule might not apply because he consented. But if he stated he did not consent and the warrant turned out to be fake or invalid, any evidence found could potentially be thrown out. Let's go deeper into the nightmare scenario for Marcus. Imagine the officers didn't actually have a warrant, but were lying to get inside. This is known as a ruse, and police are allowed to use deception in many contexts. However, claiming to have a warrant when they don't is generally considered coercive and unconstitutional. This is why keeping the door closed is your primary defense. If you open the door, you have removed the need for them to break it down. You have removed the evidence that they forced their way in. Now, let's discuss the difference between an arrest warrant and a search warrant. This is a distinction that confuses almost everyone. An arrest warrant authorizes police to arrest a specific person. It generally allows police to enter that person's home if they have reason to believe the person is inside. However, it generally does not authorize police to enter a third party's home to look for that person. This was established in the Supreme Court case Stiegel versus United States. So if the police tell Marcus, "We have a warrant for your friend David," that does not automatically give them the right to search Marcus's house. Marcus could legally say through the door, "David is not here, and you need a search warrant to enter my home." Again, the real-world application requires extreme caution. If the police hear noises inside that sound like David, they might enter under exigent circumstances. Exigent circumstances is another key legal term you must know. It refers to emergency situations where police can bypass the warrant requirement. Examples include a hot pursuit of a fleeing felon, imminent destruction of evidence, or a medical emergency. If officers hear screaming inside Marcus's apartment, they don't need a warrant to kick the door down. But in a calm situation, simply claiming we have a warrant requires them to produce it. Let's return to the moment Marcus is reading the warrant through the window. He sees that the address is correct and the judge has signed it. At this point, Marcus must step aside. But he should not remain silent. He should say, "I am stepping aside, but I am not answering any questions without my lawyer." This invokes his Fifth Amendment rights against self-incrimination. Many people make the mistake of chatting with officers during a search. They think that being friendly will make the officers search less thoroughly. This is almost always a mistake. Police are trained to gather evidence, and anything you say can be used to expand the scope of the search. For example, if they're looking for stolen electronics and you say, "I only have these drugs for personal use," you've just confessed to a new crime. Another concept to understand is the plain view doctrine. Once the police are legally inside your home, they can seize illegal items they can see. If the warrant is for a laptop, but they see a pile of cocaine on the coffee table, they can seize the cocaine. This is why limiting their entry in the first place is so vital. If Marcus had opened the door wide to talk to them, they would be legally standing in his living room. From that vantage point, anything they see is fair game. But if Marcus speaks through the closed door, they cannot see his coffee table. They cannot see the interior of his home. He has maintained his privacy shield. Now, let's discuss a common fear. Will they break my door down? If they genuinely have a valid no-knock warrant or a standard search warrant and you refuse entry, yes, they can force entry. This is why we advise you to read the warrant first if possible.
If they're smashing the door with a battering ram, you obviously move out of the way. But in most non-emergency encounters, there's a conversation phase. That conversation phase is where you exercise your rights. Let's summarize the script you need to have memorized. Step 1, do not open the door immediately. Step 2, ask, do you have a warrant? Step 3, if they say yes, say, please show it to me through the window or slide it under the door. Step 4, if they refuse to show it, say, I do not consent to any search. Step 5, if they force entry, do not resist physically, but state clearly, I am not resisting, but I do not consent. Step 6, once they're inside, state, I will not answer any questions without my attorney. Now, let's look at what usually happens when people don't know these scripts. Usually, people open the door because they're socially conditioned to be polite.
They think, I have nothing to hide, so I'll just let them look. The problem is that you don't know what they are looking for or what laws you might accidentally break. Maybe your roommate left something illegal in the common area. Maybe the officers misinterpret a legal item as an illegal one. By consenting, you waive your ability to challenge the search later. You cannot appeal a search you agree to. This is why lawyers always say, make them get a warrant. A warrant forces the police to put their probable cause in writing. It forces a judge to review the facts. It creates a paper trail that your lawyer can attack in court. When you consent, you destroy that paper trail. You make the officer the judge and jury of your privacy. Let's discuss the scope of the search again, because it is critical. If the warrant specifies drugs, they can search almost anywhere because drugs can be hidden in tiny spaces. If the warrant specifies a stolen motorcycle, they cannot look in your kitchen drawers. If you know this, you can observe the search and later tell your lawyer they looked in the drawers even though the warrant was for a motorcycle. This could lead to the suppression of any evidence found in those drawers. But remember, do not physically block the officer's hand. Just observe, remain silent, and remember the details. Recording the encounter is also a powerful tool. In most situations, you have the right to record police in your home, provided you do not interfere with their work. Pulling out your phone and recording the interaction can provide objective proof of what was said. Did they actually claim they had a warrant? Did they refuse to show it? Did you clearly state you did not consent? A video recording answers these questions definitively. Let's briefly touch on constructive entry. This is when police don't fully enter, but their actions force you to come out or submit. Courts look at the totality of the circumstances to determine if a reasonable person felt free to decline the request. If 3 officers are surrounding your door with hands on their holsters, a court might find that you were coerced. But you should never rely on a judge saving you later if you can protect yourself now by using the right words. The phrase, I do not consent, is your shield. It is simple, it is polite, and it is legally powerful. Let's talk about the aftermath. If the police search your home and take your property, you need a receipt. They are generally required to leave an inventory of what they seized. Do not sign anything that says the search was voluntary. Only sign the receipt for the items taken, if required. Immediately after they leave, write down everything you remember. Who were the officers? What did they say? What time was it? Then call a criminal defense attorney immediately. Do not talk to the police simply to clear your name. That is a trap. The police are expert investigators. You are not an expert suspect. Let's review the takeaways from this lesson. Your home is your castle, protected by the 4th Amendment. That protection is strongest when the door is closed. A claim of a warrant is not the same as seeing a warrant. Bumper versus North Carolina teaches us that consent based on a false claim of a warrant is invalid. However, you must verbally assert your rights for them to be effective. Use the window to check the warrant. Look for the signature and the correct address. Never physically resist, even if they are wrong. Always state, "I do not consent." Always state, "I want my lawyer." These are not magic words that will make the police vanish, but they are legal anchors that secure your defense for the future. Every time you waive a right, you make the government's job easier and your defense harder. Legal literacy is not about being anti-police. It is about being pro-Constitution. It is about ensuring that the checks and balances designed by the founders actually work. So the next time you hear that heavy pounding on the door, take a deep breath. Don't be Marcus. Don't open the door out of fear or confusion. Stand your ground, use your voice, and protect your rights. If this video helped you understand your rights, make sure you subscribe, because the law only protects people who know the law. Every week, I break down real police encounters, real court cases, and real constitutional protections so you never walk into a legal trap unprepared. Turn on notifications, because one video could save you thousands of dollars, months in court, or even your freedom. Stay educated, stay protected, and I'll see you in the next one.